5 seconds to go. Start. It is vehemently submitted by the learned advocates appearing on behalf of the state as well as the prosecutrix that the present case is not a case of mere breach of promise to marry as contended by the learned senior advocate appearing on behalf of the accused. It is submitted that in the present case, from the very beginning and from the inception, the intention of the accused was not to marry with the prosecutrix, and he was to marry one another lady, Radhika Soni. It is submitted that despite the above, he called the prosecutrix at his residence, and by giving promise that he would marry, he had a sexual intercourse with the prosecutrix. It is submitted that in fact the prosecutrix initially objected to have any sexual intercourse. However, as the accused gave assurance and promise that he would marry, the prosecutrix gave consent. It is submitted that as the consent was obtained by the accused on misconception of fact, and therefore the same cannot be said to be a consent, even considering section 90 of the IPC, and the consent was on misconception of fact. Both the courts below have rightly held the accused guilty for the offence under section 376 of the IPC. It is further submitted by the learned advocates appearing on behalf of the state as well as the prosecutrix that even the conduct on the part of the accused, which is borne out from the record that when the parents of the accused and the prosecutrix subsequently met to fix the marriage, instead of remaining present, the accused ran away. It is submitted that it has come in evidence that the accused was already to marry one another lady, Radhika Soni, and therefore there was no intention on the part of the accused from the very inception not to marry the prosecutrix, and despite the same, by giving false promise to marry, he obtained the consent of the prosecutrix and had a sexual intercourse. It is submitted that, therefore, in the facts and circumstances of the case, it has been established and proved beyond doubt that the consent given by the prosecutrix was on misconception of fact, and therefore the same cannot be said to be a consent, and therefore the appellant accused is rightly convicted under section 376 of the IPC. Learned advocates appearing on behalf of the respondent state as well as the original complainant prosecutrix have relied upon certain decisions of this court on section 375 of the IPC, section 90 of the IPC, and on consent on misconception of fact and on consensual sex, which will be referred to and considered hereinafter. Now, so far as the reliance placed on the decisions of this court relied upon by the learned counsel appearing on behalf of the accused referred to herein above, learned advocates appearing on behalf of the state as well as the original complainant prosecutrix have submitted that none of the aforesaid decisions shall be applicable to the facts of the case on hand. Stop.